Welcome, everyone. We'll give everyone a minute or two to come on in. You have reached talking about the Bill of Rights, and we have a lot to go over tonight, so I look forward to having everyone join us for that. Getting everyone's wandering in here. Probably a few more minutes. So while people are coming in, my name is Terry Lucas. I'm from the Shelter Island Public Library. And I'll let Mara introduce herself.
Hi, I'm Mara Zonderman. I'm from the Westhampton Free Library.
And we had a lot of other libraries that sponsored this program tonight, so I want to thank them. So we want to thank the Ammendments Library, Cutchogue Library, East Hampton, Floyd Library in Greenport, Hampton Bays Public Library, Mattatuck Laurel Library, North Shore Public Library, Port Jeff Library, Quogue Library, and Southold Library. So we thank them all for putting this program out there so you can all join us tonight. So we slow down a little bit. I think we have.
I think so.
Okay.
Yeah, so just some procedural stuff. We're gonna talk, hopefully not for too long. Um, and then we'll open it up for questions at the end. Um, Everybody should feel free as we go along to put any questions you have in the chat, and we will get to as many of them as we can. So I guess, are we ready to get started?
Yeah, let's start.
All right,
Okay.
I will share my screen. And oh, Terry, you have to
Make you
give me
host.
permission to share.
Okay, let's see. Let's see. Okay, give that a shot.
Oh, look, now I have way more choices.
So we're going to cover tonight a lot. We're covering the Second, Third, and Fourth Amendments.
At
So
least that's the plan.
well, yes, here we go. So talking about the Bill of Rights, Second, Third, and Fourth Amendments. And buckle up. Here we go. Mara, you want to do the first slide? So the second says a well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So I'm going to cover a little history, and then Mara will go into some of the cases that have covered this amendment. So some historians trace the roots of the Second Amendment to the English Bill of Rights of 1689. And that said, subjects which are Protestants may have arms for their defense suitable to their condition and as allowed by law. And at this time, King James militias were coming in and taking weapons from citizens and using them to bolster the king's store of weapons. And they weren't very happy. Will you do the next slide for me? So when King James fled to France, it was seen as an abdication of the throne, even though he was pretty much forced out. And William of Orange and Mary became king and queen, and they were co-rulers. And the Parliament at that time created a Bill of Rights, and that was the 1689 Bill of Rights. They had William and Mary sign it into law. At this point, the Parliament was pretty strong, although they still wanted to keep the idea of the monarchy. So this Bill of Rights also stated that raising or keeping a standing army within the kingdom in time of peace, unless it be with the consent of Parliament, is against the law. This is something that's going to kind of come up as we go along here, because there was a real fear of a standing army among the colonists. So in the early days of America, the citizen militias were often formed just for the common defense. Standing armies, again, were viewed with strong distrust, and some of the very early state declarations of rights specifically stated concern. The 1780 Massachusetts Declaration said, "The people have a right to keep and bear arms for the common defense. And as in time of peace, armies are dangerous to liberty. They ought not to be maintained without the consent of the legislature, and the military power shall always be held in exact subordination to the civil authority and be governed by it." So there was, again, you can see that the big concern was the government taking over and using the military to enforce that power. The next slide, please. So the Anti-Federalists were concerned with a centralized military power. They didn't want to give too much power to the federal government, and they, again, mistrusted the standing army. So the debate around the Second Amendment during ratification was pretty extensive. The Federalists wanted to have a standing army because they didn't think it was really reasonable or even doable to have all these separate little militias or separate little state armies in case something required them to have a, an army that was all on the same page. So in Federalist Paper number 29, Hamilton tried to justify organizing defense at the national level by emphasizing that militia members would remain loyal to their own communities and thus tyranny would be avoided. He believed it would serve the nation better if the militias were more formally and centrally trained. At this time, it was really hard to determine who had a weapon, who had a rifle, and what it was it in a safe and working condition. If we had to rely on just kind of hoping and guessing, it would seem a little bit dicey. So, if the militia was to be well regulated, someone had to see to that, and so it was a bit of a tightrope they were um, walking. The founders believed that a well regulated militia was essential for security. So the Constitution contained provisions for Congress to establish and fund an army and to call in militias in certain circumstances. These provisions were limited by a 2-year limit on army appropriations and other limitations, but the ongoing fear of too strong a central government remained. So the founders were concerned about unregulated militias as well. And I think we talked about Shays' Rebellion in one of the earlier sessions we had. And that took place in 1786, 1787, where citizens rose up and responded to the government's attempt to collect taxes by attacking the army and taking the weapons. But because under the Articles of Confederation, the states were not allowed to finance troops, um, it was very hard to put down this rebellion, and it took quite a long time. And eventually, Massachusetts state had a militia that was formed and put down the rebellion. So there was concern about the power shift from state to federal government. Founders were concerned about relying on unorganized individual militias. So, in the midst of all this, James Madison took on the task of writing the first draft of the Second Amendment. And his version read, "The right of the people to keep and bear arms shall not be infringed, a well armed and well regulated militia being the best security of a free country. But no person religiously scrupulous of bearing arms shall be compelled to render military service in person." So during the debate, what really kind of struck a chord was the religious exemption. So that's where most of the dissension came about, and most of the concern came about, and the rest of the Second Amendment kind of kind of took place a little bit more easily. Um, they Some people proposed that religious sects that were religiously scrupulous should be spelled out in the amendment. Still, others thought that those who opted out should have to pay a fee or provide a substitute. So finally, Elbridge Gerry suggested the phrase "trained to arms" after a well regulated militia to make it clear that it was the duty of the government to provide security. So debate continued. Final form omitted the religious scruples clause and omitted for the common defense, which was proposed along with limitations on the standing army. And the final version was finally agreed to in late September 1789. For many years, the Second Amendment was not deemed controversial. Those living in the 18th century kept weapons in case they were called to serve in the militia and for more practical reasons, such as hunting and self protection. Weapons today, of course, are very much more sophisticated, and the standing military in the United States is a very set idea and very powerful. So, not all of us keep guns in case we're called to serve on a militia. And the interpretation of the Second Amendment has become much more complicated. So, Mara's going to spend some time talking about some of the various legal cases where the meaning and intent of this amendment were addressed. So, Mara, I turn it over to you.
All right. So, as Terry just mentioned, in the 1700s and 1800s, the focus was very different than what we think of it today in terms of what the Second Amendment means. Early cases focused on the militia language rather than the bear arms language. Um, and and for the first 150 years or so, found that the Second Amendment did not apply to state governments. Those of you who have been with us for our past several sessions have heard us talk about how the First Amendment applies to the states through the 14th Amendment. Um, it it wasn't the 14th Amendment didn't come and they didn't say, okay, this makes all the Bill of Rights apply to the states. It was a process of they called it selective incorporation. And it took a while for the courts to consider that the Second Amendment should apply to the states. So there we go. Um, so the first case, actually, I'm getting ahead of myself. The first case is actually from 1875, United States v. Cruikshank. And in that case, they literally said, I quote, "The Second Amendment means no more than that the right to bear arms shall not be infringed by Congress and has no other effect than to restrict the powers of the national government." Jumping forward just 11 years to 1886, we have the case of, this isn't the right one either, sorry, of, Presser v. Illinois. And the question there is, does the state of Illinois have a monopoly on the right of its citizens to form a militia, or can only the federal government regulate local militias? So the issue there was that Illinois state law precluded any body of men, of course, men, whatever, other than the regular organized volunteer militia of this state and of the troops of the United States to associate themselves together as a military company or organization, or to drill or parade with arms in any city or town of this state without the license of the governor thereof, and authorized a fine of up to $10 or imprisonment for up to 6 months, or both, for violators. So in Chicago, in December of 1879, Herman Presser, on horseback, rode at the head of a parade of approximately 400 members of the group Lehr and Verein. This company was armed with rifles, and Presser carried a cavalry sword. Now, neither of these pictures are of Presser in particular, but this is the group that he was leading. The company had no license from the governor to drill or parade as a part of the militia and was not part of the regular organized militia of the state. So he was fined. Um, Interestingly, and again, for those of you who were with us when we talked about the First Amendment, they made a First Amendment claim here that the rule violated their First Amendment rights because they were assembling under their First Amendment rights of freedom of assembly. And the court said, no, the right to peaceably assemble was not protected unless the purpose of the assembly was to petition the government for a redress of grievances, which was not the case. And they were just marching to march, basically. But then, moving on to the Second Amendment, the court said, in view of the fact that all citizens capable of bearing arms constitute the reserved military force of the national government, the states cannot prohibit the people from keeping and bearing arms so as to deprive the United States of their rightful resource for maintaining the public security. But, so going back to what Terry was just saying, at the time, people had weapons for any number of reasons, one of which is that if they were called up to a militia, they would be expected to provide their own weapons. But in this case, the court said that Illinois wasn't trying to prevent people from bearing arms, only from marching with them in parade in contravention of this particular statute. So the Second Amendment was not implicated. But then we had the National Firearms Act of 1934. So we're jumping forward 50 years-ish. And what was going on in 1934 is, as students of history will know, is prohibition. And along with prohibition came a lot of mob violence, which created the desire in Congress for a taxation and registration program known as the National Firearms Act, which President Roosevelt signed into law in 1934. It was fairly specific at the time. It applied to short barrel shotguns and rifles and to fully automatic weapons like machine guns. Didn't take very long for there to be a case. In United States v. Miller, two men with criminal records, there's one of them, that's Mr. Miller, were charged with unlawfully, knowingly, willfully, and feloniously being in possession of an unregistered and untaxed firearm, to wit, a double-barrel 12-gauge Stevens shotgun having a barrel less than 18 inches in length. This is not the exact gun at issue, but it was very much like that. And the court was still questioning, they were looking very closely at the militia part of the language. So the question was, does the National Firearms Act and its restriction on these types of weapons prevent the formation of the militia? And the court said, the signification attributed to the term militia appears from the debates in the convention, the Constitutional Convention, the history and legislation of colonies and states, and the writings of approved commentators. I don't know who they consider to be approved commentators, but there you are. These show plainly enough that the militia comprised all males physically capable of acting in concert for the common defense. A body of citizens enrolled for military discipline was the language. And further, that ordinarily, when called for service, these men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Pay attention to that phrase, it will come back again. But they said the National Firearms Act did not violate the Second Amendment because the court couldn't find any reasonable relation to the preservation or efficiency of a well-regulated militia, and therefore cannot say that the Second Amendment guarantees to the citizen the right to keep and bear such a weapon. So again, we're talking about sawed-off shotguns and automatic machine guns. Think, Al Capone. Jump forward to 2008. We have a case that many of you may remember, District of Columbia v. Heller. So at the time, the District of Columbia's handgun ban was the strictest in the country. So if you're going to test the case, you don't want to start with a moderate one. You want to go right to the top and have them say yay or nay. So the facts, Dick Anthony Heller, there he is speaking into the microphones in front of the Supreme Court, was a security officer, and he tested the case. He carried a gun while on duty guarding a federal building, and wanted to be able to keep his guns at home for self-defense. At the time, the District of Columbia law not only bans ownership of handguns, but requires other guns like rifles and shotguns that may legally be kept in the home to be disassembled or kept under a trigger lock. It was one of the first laws passed in the District of Columbia after they received home rule authority from Congress. So, Justice Scalia wrote the opinion for the court. And again, he's talking about the militia. The militia reference in the first part of the amendment simply announces the purpose for which the right was codified, to prevent elimination of the militia. He found the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that this right, unlike some of the other English rights, was codified in a written constitution. So he went back, he looked at Miller, he said, we read it only to say that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. Nothing in our opinion, he said, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So in other words, he's saying if it's a weapon in common use, you can have it. Machine guns are still off the table, as apparently are short-barreled shotguns. Just 2 years later, McDonald v. City of Chicago, which after DC's handgun law was struck down. Chicago had the second most strict. But there was a very fundamental difference here. Um, so after Heller, Chicago residents, including Otis McDonald, there he is, sued the city, alleging that the almost total ban on handgun ownership by private citizens left them vulnerable to criminals. The Seventh Circuit, which governs Illinois, had previously upheld the constitutionality of the handgun ban, and had not, since Heller had been decided, had explicitly refrained from making a decision on purpose so that it would be decided by the Supreme Court, or so that the Supreme Court wouldn't have to overrule them, I guess is probably more accurate. So this is where we start to get uh, into this question of, does the Second Amendment apply to the states? Because the Supreme Court said the handgun ban in DC was unconstitutional, but remember that DC isn't a state.
Mhm.
So the 14th Amendment was not implicated. So the first thing the court did was go through the history of selective incorporation, and saying basically that, okay, this is our first opportunity to do so. We are going to say that the Second Amendment applies to state governments and lower as well. And the reasoning for that is that, as he said, the governing standard is whether a particular Bill of Rights protection is fundamental to our nation's particular scheme of ordered liberty and system of justice, or whether it is deeply rooted in this nation's history and tradition. And finding that self-defense is a basic right recognized by many legal systems from ancient times to the present day. And in Heller, we held that individual self-defense is the central component of the Second Amendment right. Chicago's ban violated the Second Amendment. And it's this question of, is it this fundamental right? And they found that it is historically, bred into us from the very beginning of our country. There followed several other cases that sort of narrowed or expanded what the Second Amendment means. In 2016, the court found that the Second Amendment covers all weapons that may be defined as bearable arms. In this case, it was stun guns, um, even if those weapons did not exist at the time of the Bill of Rights and are not commonly used in warfare, because that was another aspect. They said, remember, we're expecting people to bring their guns when they're called to the militia.
Mm.
But the Supreme Court says, no, it's not about that anymore. It's about what is commonly available and used. Um, in 2022, there was a New York law um, requiring anyone wishing to carry a concealed firearm to prove that proper cause exists for the concealed carry permit by demonstrating a special need for self-protection distinguishable from that of the general community. And the court said, no, none of the other rights require anybody to make a specific argument to any government official. And so this one too. So if you're going to say you can have a concealed carry permit, you don't have to prove anything special to get it. Whatever the paperwork is, you have to do it. There's nothing wrong with the concealed carry permit. It was this extra requirement. In 2024, the court ruled that a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger, does not convert the rifle into a machine gun for the purposes of federal gun control laws. So bump stocks are okay. The government cannot regulate or cannot prevent people from having them. Again, remember that regulations are okay, some of them. But then remember, Scalia was very careful to say that the government has the power to prohibit certain types of people from carrying weapons, felons, the mentally ill, et cetera, et cetera. So in 2024, uh, the respondent was indicted under a federal statute that prohibits individuals subject to a domestic violence restraining order from possessing a firearm. He threatened his girlfriend. She got a restraining order. Part of the restraining order was that he had to surrender any weapons in his possession for the duration of the restraining order, which I believe was 2 years. Um, and the court looked back to what Scalia said in Heller and found that prohibitions like those on possessions of firearms by felons and the mentally ill are presumptively lawful. So that was a case where the Second Amendment was not implicated when this man was told he could not have his guns. Most recently, just last year, in a case called Bondi v. Vanderstock, dealt with the question of ghost guns. And again, many of us may remember this, hearing about it in the news. In 2022, the Bureau of Alcohol, Tobacco, and Firearms adopted a rule that would apply the Gun Control Act of 1968, which I mentioned before, to weapon parts kits and unfinished frames or receivers, commonly known as ghost guns. The argument was that ghost guns are required as parts, and the parts considered separately can't be considered a weapon. So there they are in their parts, which could be ordered online and delivered with no proof, no background check, no nothing. And a half an hour later, you put it together and there you have your weapon. And Neil Gorsuch, Justice Gorsuch, authored the opinion. And he said, an author might invite your opinion on her latest novel, even if she sends you an unfinished manuscript. A friend might speak of the table he just bought at IKEA, even though hours of assembly remain ahead of him.
Hmm.
In both cases, the noun fits because the intended function of the unfinished object is obvious to speaker and listener alike. The term weapon can work this way too. Imagine a rifle disassembled for storage, transport, or cleaning. It may take time to render the rifle useful for combat, but its intended function is clear. And as a matter of everyday speech, that rifle is a weapon, whether disassembled or combat ready. In the same way, and for the same reason, an ordinary speaker might well describe the buy, build, shoot kit as a weapon. Yes, perhaps a half hour of work is required before anyone can fire a shot, but even as sold, the kit comes with all the necessary components and its intended function as instrument of combat is obvious. Really, the kit's name says it all. Buy, build, shoot. And I think a lot of people at the time were somewhat surprised by that ruling, because up until that point, for the most part, the court had been pretty permissive in what it was defining under the Second Amendment. But in this case, they said it's not that you can't get these anymore. It's that you have to follow all the rules and regulations that apply to guns, whatever they happen to be where you are, background checks, etc. There are a couple of cases before the court right now. We're waiting on decisions. The first one, Wilfred v. Lopez, asks whether Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property that is open to the public, unless the property owner affirmatively gives express permission to the handgun carrier. So this is super specific. And we're not talking about can you have a concealed weapon, because you can if it's licensed. We're not talking about can you have it on public property. We're not talking can you have it on your home, in your home. We're talking about if you go onto private property that is open to the public, do you have to have express permission from the owner of the property? This case was argued on in January, and the majority of the court appeared to side with the gun owners that the prohibition violates the Second Amendment. The other case that we're waiting on a decision on is United States v. Hemani, whether the gun control's prohibition on the possession of firearms by a person who is an unlawful user of or addicted to any controlled substance violates the Second Amendment. This case was argued just last month, and many justices seemed skeptical, not necessarily that such a rule couldn't be enforced, but that its terms weren't being defined narrowly enough. And we don't need to get into all that. But one interesting thing that came out of those arguments is, you know, the argument was made, well, the founders could not have meant that people who habitually get high or drunk couldn't have guns because the founders were all, as they said, habitual drunkards. Which is, not historically inaccurate, right? I mean, they drank ale. Um, you know,
Not a lot of water drinking back then.
right. So, it's an interesting article, and I'm very curious to see what the court has to say about that when they hand down their opinion in the next month or two. So that is where we stand with gun control legislation, at least at the federal level, as applies to the Second Amendment.
Thinking
Uh,
it's really interesting to kind of look back from, where when it was written, and I know people like to take the original meaning of the Constitution, and it's, but time changes, and the interpretation necessarily has to change, because we can't, they could not limit this to militias. Well, they probably could, but they have not. So
despite some of them calling themselves originalists.
yeah, yeah,
But
there we
we'll
go.
move on.
We'll move on. Let's
All
move
right.
on to the Third Amendment.
Third
Okay.
Amendment.
All right. So, Third Amendment is one that was deemed very important again at the time of writing the Constitution. So, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So the quartering of soldiers by the powers that be has a really long history. During the time of the Roman Republic, soldiers were quartered to both show the power of the government and to cause economic hardship and kind of punish people. In 17th century Britain, the English Parliament reacted to the involuntary quartering of soldiers by King Charles by passing the Anti-Quartering Act in 1679. And then we go back to 1689 again to that declaration. King James II's practice of quartering his army became one of the justifications for his ouster, and the Mutiny Act of 1689 specifically protected against enforced quartering. So the next slide, please. Okay, so the Quartering Act of 1765 was passed by the British Parliament to deal with housing British soldiers who were in America to fight the French and Indian War, also known as the 7 Years' War. The Quartering Act was also called the American Mutiny Act, and stated that private citizens could not be forced to house British soldiers, but they had to pay for barracks and supplies for the troops. Colonies, again, not happy with this, and it was a strain upon their finances. They especially rebelled against finding places for soldiers to stay, especially the ones that were sent to quell the unrest caused by the Stamp Act. So, in the next slide, I'm going to tell a little story about the Manufactory House. In October of 1768, the issue of quartering soldiers came kind of to a head in this manufactory house, which is very difficult to say. The Manufactory House was a two-story brick building that served as a refuge for Boston's most destitute residents, the sick, the poor, the homeless. The sheriff of Boston, with a few other people in charge, decided that the house would be a good place for soldiers' barracks. So he entered the house with the intention of evicting the residents. But the people inside took him hostage and barricaded the building and detained that sheriff until he was eventually rescued by the British soldiers. The soldiers then surrounded the Manufactory House, trapped the people inside with no food or water, and after a few days, they gave up, went away, and the Manufactory House residents remained in place. So there's an evidence very early on that a requirement to quarter soldiers was not a popular thing in this new world. So in 1774, the Quartering Act was passed partially in punishment for the Boston Tea Party. It required colonists to house British soldiers in private homes with no compensation. This act, combined with the coercive acts, or the intolerable acts as they were known to the colonists, helped to lead the colonies on to revolution. And during the revolution, weirdly, both British and Continental armies actually did require citizens to take soldiers into their private homes, despite the law forbidding it. The colonists held a general belief that their homes were their castles, and they fought the invasion of soldiers from both sides. So that's a little history of what the criminal justice writer Radley Balco called the runt piglet of the US Constitution. I just love that. And so Mara is now going to tell us a little bit about this runt piglet of an amendment.
So the reason it's called that is because there has literally never been a Supreme Court case on the Third Amendment. I was able to find one case coming out of the circuit courts, but before I do that, here is the reason that there has never been uh, a case.
Wish to order in your home. Under the Third Amendment, I decline your entry.
Yay!
Um,
Simple as
so,
that.
so thank you to Ezra, my younger son, and my husband Sam, who fulfilled a lifelong dream of teaching a course on the Third Amendment, um, for directing and filming that. But basically, that's it, right? Knock on the door. I want a quarter in your house. No, there's not much more to
Yeah.
say. There was a case that I did find interesting, and it actually came out of New York, in the early 80s. During a statewide strike of corrections officers, this actually happened in 1979. Petitioners to corrections officers were evicted from their residences, which were on the grounds of wherever it was that they were guarding, without notice, and their residences were used to house members of the National Guard without their consent. So the Second Circuit found that, first of all, that National Guard troops are soldiers within the meaning of the Third Amendment, and that the Third Amendment is incorporated into the 14th Amendment for application to the states. Okay, so that's all well and good. But then the question became whether these two people had sufficient property interest in their residences to give them Third Amendment protection. And the court actually looked back to the 60s to a case called Griswold v. Connecticut, which was the first case where we really started to talk about the idea of privacy.
Mhm.
And the court said that considering privacy, they had a reasonable right to a legitimate expectation of privacy in these homes, even though they didn't own them and really only had them pursuant to their jobs, but they were their homes. They didn't have any other homes, and they could reasonably expect to be to have their privacy included. So the Third Amendment was implicated here. Um, so in the state of New York, the National Guard can't come in and say they have to quarter in our homes. Um, but again, that's the only the only case. So much for the Third Amendment.
It was short and sweet, and
Short and sweet, right?
I think it was definitely a reaction to what the colonists had been through, and they were going to make sure it was spelled out. But someone knocks on your door and says, "I'm going to come live with you." You say no. No,
Especially if they're wearing
an
a,
army.
a takeout hat on their head.
Magnus hat. Thank you to Sam and thank you to Ezra for illustrating this. We
Yes.
appreciate it. So we move on. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this is pretty specific. The right to be secure from search and seizure was long-standing in English common law and was so deeply ingrained in the thoughts of those writing the Constitution that it was pretty specific in the way that it was written. Every man's house is his castle, as we talked about before. It was pretty much a celebrated maxim in England, and it came over to the colonies. So in the colonies, officials would enter the houses upon writs of assistance. Writs of assistance were meant to catch the people who were not following the revenue laws. They were either smuggling or they were not paying the taxes, whatever the those terrible laws were that they were fighting. That's what they used these writs of assistance. So writs of assistance were general warrants. They authorized the official to enter any house or other place and search for and seize prohibited goods. The colonists felt that if government officials could search their homes and seize goods at will, nobody could feel safe. So the writs played a very large part in the unrest that resulted in the Revolution. There was an English statute that provided that the writs of assistance expired upon the death of the king. So when George II died in 1760, the writs had to be reauthorized. So the Massachusetts Bay Colony petitioned the court in Boston to reauthorize the writs. Next one. I think I've got John Adams and James Otis kind of mixed up, but here's John, there's James. James was the acting advocate general for the Bay Colony, and in 1761, he was asked to argue on behalf of reissuing the writs. He refused. He stepped down from his office and instead represented the merchants who opposed the writs. And in a 5-hour speech, which was witnessed by the young John Adams on the previous slide, Otis argued that the writs were unconstitutional. He based his case on the rights guaranteed in English common law. He said, "Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, if it should be declared legal, would totally annihilate this privilege. Custom house officers may enter our houses when they please. We are commanded to permit their entry. Their menial servants may enter, may break locks, bars, and everything in their way, and whether they break through malice or revenge, no man, no court can inquire." Otis, of course, lost, but you can find the text of this 5-hour speech, and he was passionate for a very long time. So after the revolution, John Adams, who had heard the speech, became concerned that this new government might disturb the privacy and safety of the new Americans' homes. So he drafted Article 14 of the Massachusetts Declaration of Rights, which said, "Every subject has a right to be secure from all unreasonable searches and seizures of his person, his house, his papers, and all his possessions." So numerous other states at the same time were drafting their Declaration of Rights or constitutions, and many of them adopted this as well and protected their citizens from unreasonable searches and seizures of their persons, papers, or property. Because this right seems so settled, there were very few changes made to the amendment in committee. And by drafting the Fourth Amendment, the framers just sought to guarantee the future generations the same property rights and protections they had acquired over centuries under the common law of both England and America. There was very little debate. It went through pretty easily. But what seems straightforward to the framers of the Constitution has come to be interpreted in a variety of ways over the years. One scholar, George C. Thomas, wrote, "History is helpful. The text of the Fourth Amendment is not." He went on to say, "The text of the Fourth Amendment provides no guidance about what makes the search unreasonable or when warrants are required to make a search reasonable. The Supreme Court has had to craft a doctrine based on intuition, policy goals, and half-hearted stabs at history." So with that, I will turn it over to Mara, who will discuss this amendment and the difficulties that it has caused over time.
Yeah. So maybe the next thing I'll get Ezra to reenact is this 5-hour speech.
There you go.
We'll speed it up. Anyway, so yeah. So as Terry said, the text of the Fourth Amendment does not actually provide a lot of guidance. So most of what we talk about is what the courts have said um, have said it means. But rather than go through case by case as I've done in the past, I think for this one, I want to talk about how do things stand right now. So what is a warrant? What do you need to have a warrant? I will say the requirements for search and seizure warrants are generally the same as for arrest warrants, but we'll talk about that next time. That's a different amendment, even though the requirements are the same. So the first thing that a police officer needs to have is a neutral and detached magistrate. And you'll notice that it's not a judge per se, although often it is a judge who will issue a warrant, but it's a magistrate. In other words, it's somebody, an official of the court, who is not directly involved in law enforcement, because separation of powers, right? We don't want the people who want the warrant to be in charge of approving the warrant. And who can be the magistrate varies from place to place, but um, you need to have someone who is neutral and detached. You need to have probable cause. Um, again, the Fourth Amendment does not tell us what probable cause is. So the courts have said that probable cause is you need only be concerned with the question whether the affiant, the police officer, had reasonable grounds at the time of the affidavit or the request for the belief that the law was being violated on the premises to be searched. And if the apparent facts set out in the affidavit are such that a reasonably discreet and prudent person would be led to believe that there was a commission of the offense charged, there is probable cause justifying the issuance of a warrant. Not a very high standard, um, but there it is. A discreet and prudent person goes along with neutral and detached. The idea being that this should be some third party with no direct interest in the case. The warrant also has to have particularity, which limits officers to looking in places where the object described, whatever they're looking for, can be expected to be found. Part of the reason behind the particularity requirement is to assure the person whose property is being searched that the officer doing the search is acting within the law, that there's proper documentation of the search, and that documentation must be shown to the person whose property is being searched. So in other words, I say to the magistrate, I think I have to go into somebody's home to search for this particular type of evidence. So you go, but if you're looking for, take your pick, you can't look in the pool if you're looking for a gun, because that's a really bad example, but you get my point, right? They're limited to looking for what they say they're looking for. It's not a general search. Lastly, the requirement, and this is more a requirement of the execution of the warrant, not the warrant itself, is this knock and announce idea. So before, generally speaking, the officers can't just bust in. They have to knock and announce their office, their authority, and the purpose of their search. There are a lot of exceptions to the knock and announce. The primary one being, well, what do they do if nobody answers? In that case, if they have reasonable suspicion, or that, well, they already have reasonable suspicion, but if nobody answers, and they have announced, that being the important part, that it's the police, they can bust through your door. Also, they do not need to knock and announce if they have a reasonable suspicion that announcing their presence under particular circumstances would be dangerous. If they think somebody's going to be standing on the other end of the door with a gun, or futile, or that it would inhibit the effective investigation of the crime. So in other words, knock, 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 police, oh, quick, let's, flush everything down the toilet, right? Um, if they have a reasonable suspicion that evidence would be destroyed, for example, they do not need to announce their presence. But courts consider this on a case-by-case basis. There's no global standard. It's in this particular case, did these circumstances allow for no knock and announce, or for a knock and announce and go in even if nobody answered? So what makes a warrant valid? A court will look at the totality of the circumstances. Was the magistrate's consideration a practical common sense decision? So, for example, in a case involving an anonymous informant, the Supreme Court concluded that the veracity, basis of knowledge, and reliability of the informant are some of the relevant factors an issuing magistrate might consider. Although the informant's anonymous letter in this case might have been insufficient by itself, the court concluded that the issuing magistrate could have found probable cause, did in fact find probable cause, based on other factors, such as an initial investigation by law enforcement that had verified several predictions that had been found in this letter. So they're not looking, the police officer says, hey, we have this letter. The court does not require the magistrate to say, that's the only thing I can look at is this letter. I can look at all the circumstances surrounding. And again, this is becoming a theme, right? Common sense. Magistrates may employ common sense and make reasonable inferences when deciding whether evidence is likely to be found in a particular location. For example, law enforcement documented a defendant's involvement in delivering cocaine to another person and obtained a warrant to search the defendant's home for evidence of drug trafficking activity. Even absent any evidence relating to the defendant's home, the Ninth Circuit, in this case, upheld the issuance of the warrant, reasoning that depending on the nature of the evidence and the type of offense, a magistrate may draw reasonable inferences about where evidence is likely to be kept, and that in the case of drug dealers, evidence is likely to be found where the dealers live. Okay? Speculation. Inferences may support a finding of probable cause, as we've just discussed, but speculation generally does not. So in this example, law enforcement obtained a warrant to search the defendant's girlfriend's home after the defendant brandished a gun at a Waffle House. The Fifth Circuit ruled the warrant invalid because the affidavit, the asking for the warrant, offered nothing, no observations, no inferences, no corroborated tips linking the Waffle House incident to the girlfriend's apartment. The court found that while some inherently domestic items like personal papers could be reasonably inferred to be in a home without further factual support, the same could not be said for firearms, and speculation about what might be found at a residence cannot satisfy the Fourth Amendment. If the warrant had been for the defendant's home, that would have been a different question, but they were not willing to speculate that he kept his guns at his girlfriend's house. Training and experience. I just broke my paper on the floor. Excuse me. The magistrate may rely on the training and experience of the officers. Basically, they've been doing this a long time. The example is it was a child pornography case, and the officer came in and said, I want a warrant to search this guy's car. And the officer had done many cases similar and told the magistrate, pedophiles typically keep stuff in multiple locations, whether it's paper or on electronic devices or so on and so forth. So the magistrate relied on that to say, okay, go ahead and search the car, and the court did find that to be okay. Staleness. Generally speaking, a magistrate can't issue a warrant in 2026 and have the warrant be served in 2029, because too much will have changed. An exception to that is for things like financial records. Some financial records you're required to keep for a certain period of time. So even if the warrant is several years old, and you're going to go search the house, this is a good one. You can't search the pool for the records because they won't be in there, or they won't be readable. But you can search many years later, because there is a reasonable expectation that those things will still be around and the records themselves don't expire. So those are some of the things that make a warrant valid. Also, there's deference to probable cause determination. The courts give great deference to the magistrates as the person who's there hearing the arguments with the evidence. Generally speaking, unless there is some, obvious flaw in the warrant or its execution, a court will uphold a magistrate's issuance of a warrant. There are some exceptions. You do not need a warrant, a search and seizure warrant, if there's a lawful arrest going on. So if you get arrested, they can search your person, generally speaking, or your car if you're in the car. They do not need a specific warrant for that. Obviously, they don't need a warrant if you consent to be searched. The officers don't need a warrant if there's some sort of emergency going on. A typical one might be a drug overdose. They need to know what the drug is. They can search the immediate perimeter to try to get that information. If a felon is fleeing, even if there's no arrest warrant, but they're in hot pursuit, I don't know what qualifies as hot pursuit, but that's a separate question. There's no need for a warrant there either, because you don't have time to get one, basically. If the officers think that there will be imminent destruction of evidence, we talked about that with the knock and announce rule. Even if there's no warrant, if you think, if the officer thinks that they're going to destroy the evidence immediately and there's no time to get the warrant, they can present that as an exception. And vehicle searches, when there is probable cause on the part of the officer to believe that there is contraband, usually drugs. But so, that's the classic sort of traffic stop, and we smell weed, right? So they do not need a warrant in those cases. Or when the evidence is in plain view. This is called the open fields rule. If you're in a place where there's no expectation of privacy, then you have no expectation of privacy. That does not apply necessarily to your person, but if you're storing it, this is if you watch Law and Order and they're going through people's garbage, that's the open fields rule, right? Because you don't have, once you put it outside, it's outside. You don't have any more expectation that it will be private. And that is what we have on the Fourth Amendment. So I will pop up our next coming up sessions. But if anybody has any questions or comments, we have a little bit of time. Terry, how do you like that? We came in just under an hour.
Oh man, 2 minutes short of an hour. That's if you know the programs that Mara and I do together, that's a miracle. We're always kind of running over, but and we managed to get 3 amendments in there with a video. So
yes,
that was quite the Friday night miracle. But
we owe it all to the runt piglet.
The runt piglet of the Constitution. So that was a lot of information. Again, any questions or comments, please feel free to put them in the chat. Otherwise, we'll look forward to talking about the Fifth Amendment, which should be a pretty meaty one, I think. And
we do have a raised hand.
Let's see. How do we do? Let's see. Raised hand.
I think Louise wants to be unmuted, perhaps.
Okay, let me see if I can get to Louise and unmute her. Let's see. Allow to talk. Okay, Louise, I think we can you should be able to talk. You're muted, so you'll have to unmute to talk.
Yes, thank you.
You're welcome.
Yes, it was just telling me that the chat was disconnected.
Oh,
That's weird. Okay.
that explains why it's so quiet.
Okay. Let me see if I can get into the chat and make sure it's connected. But in the meantime, did you have anything that you wanted to say, or?
I mean, in terms of unreasonable searches and what I would like to raise the issue of ICE, going, and they've been very, very in Minneapolis and in Chicago. I mean, from what I heard, in the news, they just sort of went in and just destroyed things in the apartments, looking for things, looking for people. To me, they just sort of bullied their way in and smashed things and seized people. And now you hear all sorts of reports of people who were improperly seized, and that they are American citizens or they have green cards, etc., and they're wasting away in these dreadful prisons. So where does that stand? People must have brought lawsuits.
Um, any lawsuits on that are barely in the beginning stages. And lawsuits take an awful long time. So I expect we will be getting some litigation on this and some decisions from the court. But it's much, much too soon. So
It'll be a while.
it will be a while.
Yeah, it'll be a time, and I'm sure we will see multiple cases, and I'm sure there'll be somebody that is going to pick that perfect test case that they're going to want to see go to the Supreme Court. And what is the streams of law move exceedingly slowly? That's not the right quote, but it's something like that.
Yeah.
So we're not going to see anything that's responding within the next year, I wouldn't think. But I would feel very, very certain that we can tell you that this will make its way to the Supreme Court at some point. But it's, again, nothing moves fast with law. So
yeah, and frankly, your guess is as good as mine in terms of what the court will decide. Frankly, I don't know enough about what kind of warrants they have or the procedures that they're going through.
Yeah. And who's on the Supreme Court at the time it gets to the Supreme Court. So that, again, as much as we'd like to say that the law is something that is black and white, so much depends on the interpretation of the justices that sit and hear it. So it'll be, I think, as always, a lot of the things that are coming up these days, which will make their way through the legal system, we'll probably see in 4 or 5 years, and it'll be interesting. So I guess that's one way to put it. You can put something in the Q&A if you'd like. That is open. I don't know why the chat's closed, but what about Mr. Blakeman of Nassau and his militia? Oh gosh, you got me on that one. I don't know about Mr. Blakeman, Linda. So you'll have to give us a little more information about that so we can tell everybody at the next one. Shoot me an email and let me know. So tlucas@silibrary.org. I would love to hear about Mr. Blakeman. And if I don't hear, I'm going to have to do my own research. So any other questions?
We do have another raised hand.
Okay, let's see.
So I don't know who iPad 64 is, but you can go ahead and unmute yourself.
Okay.
Hi, and thank you so much for all this. These are so interesting. My question is, well, it's also related to Blakeman, but going back to the other comment, in the very beginning, when I guess a little over a year ago January, when these first, I don't know what they're, arrests, I guess, or disappearances of people started happening, we had gone to a training through our local community organization that said that that people were required to have, in order to enter, they had to have a judicial warrant. And that no longer seems to be the case. It seems to be that there's no judicial warrant, that's being presented at the time that people are being picked up. And I wonder, how do citizens respond to that when it's such a, whether these lawsuits happen in the years down the line and all that, I don't know, but how do people respond in real time, you know, to not having that required warrant? Thank you again.
I can tell you that I took some training on how to respond to ICE in the library, and they did say a judicial warrant was not an administrative warrant was required, and that basically you don't put yourself at risk. You ask for the judicial warrant. You call your attorney, you know, and do your best to get what you should get, but you don't want to put yourself in danger, and interference can be considered a felony. So it's, you know, it's a tough situation, I'm afraid. So we'll look up Blakeman so we can respond to it next time. But we really do appreciate everybody joining us and listening, and we're so excited that we have as many Constitution, Bill of Rights people that are interested in this. So we'll see you on May 29th at 6 p.m. for the Fifth Amendment, and we'll kind of clean up the rest of this as well. Okay.
Thank you.
All right. Thanks.
Thank you, everybody.
We look forward to seeing you next month. Bye.
Bye.